Good morning, good afternoon, good evening. Welcome to my YouTube channel. My name is Ogbanje Joseph. Please hit the subscribe button to subscribe to this channel, like and share this video. Today we are going to be looking at international law of treaty. International law of treaty. So to start with, what is treaty? Treaty is analogous with such terms as agreement, covenant, protocol, convention, exchange of letter, or contract. So simply put, treaty is an agreement entered into, okay, or a special form of official written agreement entered into by state actors or non-state actors to legally bind themselves on issues of common interest to the parties. Okay, so the Vienna Convention of the Law of Treaties provides a conceptual clarification of treaty when it defines the term as an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. Okay, so the major types of treaty or the major classification of treaty that we have are the bilateral treaty, which is an official agreement that involves only two states. And then we have the second one, which is the multilateral treaty, which involves three or more states. So within the international system, okay, there evolved an an interdependent system, particularly or partly because human and material resources are unevenly distributed among nations. So hence, there is a need for cooperation among state actors. So state actors interact either bilaterally or multilaterally, okay, to form common grounds on issues of interest, okay, which could be as diverse as issue of non-proliferation of arms laws, okay, trade laws, conflict resolution laws, aid laws, peace laws, politics, economic and sport laws, etc. So the various interactions become legalized when binding agreements are created between or among states. So the formal agreement between two or more countries is called a treaty. Okay, so the formal agreement between two or more countries is called a treaty. So it is worthy to note that treaties are regulated through a set of international principles known in the legal parlance as the law of treaties. So treaties aims to legally, substantiate, okay, the relationship, or cooperation between and among states. Okay, so now, what do we need to understand very quickly whenever the topic of treaty is actually introduced? Okay, now according to the Vienna Convention on the Law of Treaty, okay, according to the Vienna Convention of the Law of Treaty, now treaty is one of the most important pieces of work or pieces of work ever undertaken by the International Commission. Now, the convention was adopted by the Vienna Conference in 1969, okay, but did not enter into force until January 1980. Okay, so according to the Vienna Convention, treaty means an international agreement conducted between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments. So that is actually the definition of treaty according to the Vienna Convention. Okay, let me still take it again. That according to the Vienna Convention, okay, of 1969, they say that treaty can be defined, okay, as an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments. Okay, so that is actually what is known as treaty. So whenever we're talking about the subject of treaty, you should know that we are talking about agreement, we are talking about covenant, we are talking about protocol, we are talking about convention, our exchange of letters or contract. So any form of agreement between two or more states, any form of covenant between two or more states, any form of protocol, convention, okay, exchange of letters or contract can be referred to as treaty. Okay, so what are examples of treaty? Now let us look at examples of treaty. What are examples of treaty that we can actually lay our hands on in the international system? The first one is the 1648 Peace Treaty of Westphalia that ended a 30-year-old war. You understand? A 30-year-old war, and established the principle of sovereignty of nations. It was that 1648. That is why every international relations student, must get to know about the Treaty of Westphalia of 1648, because that was the treaty that ended a 30-year-old war, okay, among the Europeans, and then established the principle of the sovereignty of nations, okay, for the first time within the international system. That is number one treaty. That is the Treaty of Westphalia of 1648. Number two is the 1919 Treaty of Versailles that ended the First World War. Okay, the Versailles Treaty of 1919 that ended the First World War. Then we have the Bretton Woods Agreement. Okay, the Bretton Woods Agreement that actually led to this is like the commercial and financial relations among industrial states. Then we also have the 1947 Paris Peace Treaty, okay, that formally ended the second World War. So we have got among other types of treaty, we have got number one, the 1648 Peace Treaty of Westphalia. Number two, the 1919 Treaty of Versailles that ended the First World War. Number three, we have the Bretton Woods Agreement that led to commercial and financial relations among industrialized states. Then number four, we have the 1947 Paris Peace Treaty that formally ended the Second World War. Now, what are sources? What are sources of treaty? The sources of treaties are number one, official country treaty series. Official country treaty series. And you can get the sources of treaty from Article 26 of the Vienna Convention. So we have number one source of treaty is official country treaty series. That's number one. Number two, intergovernmental organization treaty treaty series. That is number two. Then number three, official gazettes. Official gazettes. Okay. Then number four, we have statutory compilations. Statutory compilations. Then number five, we have periodic literature. Periodic literature. Okay. So those are the things. Now, what are the principles of treaties? What are the principles of treaty? Number one, we have free consent. Every participating country must actually give their free consent to the treaty before it becomes a treaty. That's number one. Number two principle of treaty is good faith. It must be done in good faith. It must be done in good faith, in fairness. Okay, must have reasonableness, must actually have integrity. Okay, and all of that. Then we also have pacta sunt servanda. Pacta sunt servanda. What does that mean? It means that, of course, all countries must freely enter into that law, and that law cannot be changed once it has been freely entered into. We also have we also have Jews cogens, Jews cogens. Okay, then number 5 we have rebus sic santibus. Redus sic santibus. Then we have number 6, which is favor contracts. These are principles of treaty. Now let us look at ways in which treaties can be variated. What are the ways in which treaties can be void, null and void, or can be voided? What are the ways in which treaties can actually be referred to as null and void? One thing is that a treaty can be voided based on the following. Number 1, if it is in conflict with a peremptory norm of general international law. If it is in conflict with a peremptory norm of general international law, in which case, if it is against the norm of acceptable or accepted, or not accepted by recognized states. If it's not accepted by recognized state, then you can say that it is in conflict with the peremptory norm of general international law. That's number 1. Number 2, international treaty can be voided if at any time the countries or the participating countries, by through their consent, came to a conclusion that it should be voided, so that all the parties must have been consulted with other contractual bodies, other bodies that are part of the contract. That's actually number 2. If at any time, by consent of all parties, after consultation with the other contracting states, they decide to say that treaty should be voided. That's number 2. Then number 3. Now, a treaty can be voided if its conclusion has been procured by a threat or use of force in violation of the principles of international law embodied in the Charter of the United Nations, and all of that. So if the agreement is procured under duress, such a treaty can be variated. So these are the ways in which treaties can actually be variated, and you can get all of this under the Vienna Convention, Article 52. Thank you very much.